Supreme Court Prevention of Money Laundering Act matters. Namaskar. Today our speaker is Jayprakash Somani, advocate from Supreme Court of India and IP. He published more than 50 books on Supreme Court case law. So, I'm presenting you Jayprakash Somani.
Let's see. Supreme Court PMLA Act matters. Prevention of Money Laundering Act matters. Many big giant netas, big builders, big officers, big peoples who have the property which is not shown in the balance sheet and or the property which is not in the proportionate of their source of income. So source of income is X and property is a 10X. So that time PMLA Act will act. And the police of PMLA Act is ED, Enforcement Directorate. So ED is doing the investigation process for PMLA Act and FEMA Act, Foreign Exchange Regulation Act, FERA. So Foreign Exchange Regulation Act was earlier name. Now it is Foreign Exchange Management Act 1999. So PMLA Act, Prevention of Money Laundering Act and FEMA Act, both are investigated by Enforcement Directorate and big fish are here. So lawyer have to do too much mental exercise in our apex courts. So let me tell you some significant point related to the Prevention of Money Laundering Act 2002. Total sections of this act are 75, chapters 10, schedule 1. These are tried by adjudication authority. There is a separate tribunal to try this Prevention of Money Laundering Act. And important section are 3 to 5. 3 to 5 are a very important section as per Money Laundering Act. Section 21 shows appeal from AA. Adjudication authority, that means tribunal, appeal from tribunal to appellate tribunal should be in 45 days and appellate tribunal to High Court under section 47 of this act. And after High Court, regular ways to our apex court. So first way is certification of High Court if it is under Article 132, 133. If High Court finds some significant or some extraordinary constitutional points, substantial question of laws, so High Court can give the certification under Article 134A to file appeal in Supreme Court. And if that certification is not available, that time party can file SLP as per Article 136. And SLP should be properly drafted. Synopsis should be a very good. Impugn order means which order you are challenging in the Supreme Court, that order's negative point should be highlighted properly by the petitioner's lawyer. Give the explanation of that points properly. Give the synopsis to the point. Then give the list of dates. Then case laws, everything should be there. Then impugn order. Then regular SLP draft should be there. In regular SLP draft, question of laws and grounds are most significant points. So, if a draft is good, arguing lawyer is good, if to the point substantial question of laws he is showing to the judges, judges are very happy in apex court. They immediately will notice that matter. That means they will accept that matter and notice to respondent. And after notice, respondent will file his counter affidavit, and after counter affidavit, then regular after notice hearing will be there, arguments are there, case law are there, and then last decision of apex court will be there. And if that decision, SLP decision is not, if you are not happy with that decision, then you can go in review petition, and after review petition, curative petition will be there. So this is the little bit summary or highlights of the Supreme Court related to the PML Act, Prevention of Money Laundering Act 2002. So friends, thank you very much. Jai Hind, Vande Mataram.